Hi, everyone, and welcome to our first webinar in a series. My name is Malka Herman, and I am the Executive Director of the Rhode Center at Stanford Law School. The Rhode Center works to make civil justice more equitable, accessible, and transparent, and works to promote the legal profession's commitment to the public interest. One of the Rhode Center's focus areas is reforming legal services regulation to increase innovation and access to justice. As part of our research, we released a new book through Cambridge University Press in September, edited by Rhode Center co-directors and Stanford Law School professors David Freeman Engstrom and Nora Freeman Engstrom. In Rethinking the Lawyers Monopoly, Access to Justice and the Future of Legal Services, which is available for free online, talking about access, we want everyone to be able to access it. We bring together leading legal scholars and practitioners to propose new conceptual frameworks for reform, drawing lessons from other professions, industries, and places, both within the United States and across the world. We'll begin our discussion today by asking each of our panelists to present a certain frame for thinking about the market for legal services. Then we'll move on to a discussion of how these framings should influence how we think about design and enact regulatory reforms. We'll save room for audience Q&A, so please submit your questions. So first, I would love to introduce our distinguished panelists. Going in alphabetical order, I'm going to start with Brad Wendell. Brad is a professor at Cornell Law School, where he specializes in legal ethics and the regulation of the legal profession. He brings a nuanced perspective to today's discussion, offering a thoughtful defense of the traditional values embedded in unauthorized practice of law restrictions and the professional duties they are designed to protect. Bridget McCormick is the president and CEO of the American Arbitration Association International Center for Dispute Resolution and previously served as Chief Justice of the Michigan Supreme Court. She brings a rare dual perspective to legal services regulation, both from the bench, where she championed judicial responsibility for improving access to justice, and from the forefront of out-of-court dispute resolution innovation. And finally, Nora Freeman Engstrom, who is a professor at Stanford Law School and the co-director of the Rhode Center on the legal profession. Her scholarship explores the history and structure of legal services regulation, including her recent work uncovering the origins of the modern lawyer monopoly and its implications for the access to justice crisis. So thank you all and welcome, and we really appreciate you being here. So we're going to start with you, Nora, to provide a historical framing of the lawyer's monopoly. In much of your scholarship, and in particular your 2024 article, which is amazing and I highly recommend everyone reading, Auto Clubs and the Lost Origins of the Access to Justice Crisis, you surface the historical conditions that gave rise to the modern-day lawyer monopoly over the provision of legal services. So can you walk us through those key events and explain how early fights over UPL shaped the current and modern lawyer monopoly that we see today?
Sure. Thank you, Malka. And I have to say, it is such a thrill to be on this initial webinar in the series and joined by two panelists who I admire and respect so profoundly. So what a thrill. And thanks to those who are watching or joining today. It's really wonderful to be able to share some of this work with a broader audience. But Malka, to get to your question about how to understand the access to justice crisis today and to understand the steps states are taking right now to address this question, why would we go back in time 100 years to some dusty history? What is the point of that? And I think there is a real reason here, and it was actually something that only became very clear once my co-author James Stone, who was a Stanford student at the time, who is now a fellow at the Bigelow program in Chicago, kind of what we found was we stumbled upon this kind of, it almost felt like another world, like another outer space system of legal regulation. So when we turn back the clock 100 years, we found these things called auto clubs. And lots of folks are familiar with auto clubs. Today you might belong to the AAA and you might be thinking, well, gosh, whenever, my battery is dead or whenever I need a tow or I have a flat tire, they come to the rescue. And they did that 100 years ago. They did all of those things. But they also did something else, which is they provided wraparound legal services for all things auto. And so if you had a ticket, they would help you negotiate it. If you got arrested, they would help you defend yourself in a criminal case, all the way through habeas proceedings. And if you were injured in an auto accident, they would provide a lawyer to you, or if you injured someone else, they would provide a lawyer to you. So the auto clubs of the 1920s, which were big business, there were around 1,100 auto clubs kind of peppering the United States, provided these wraparound legal services, so encompassing legal services and in a big volume. So in 1929, for example, those 1,100 clubs handled more than 30,000 civil claims. So this is not like a one-off obscure situation. This is really handling the auto accident cases for the American public. And so, how is it and why is it that your auto club in the 1920s would provide wraparound legal services? And today, all it is towing and maps and, some flat tire needs. And the answer is in the 1930s, the organized bar turned on the clubs and shut down, or at least shut down the provision of legal service regulation. And we think that in the story of the clubs in their heyday, providing these, by all accounts, high quality legal services to the American public, there's something there. It points the way to a different arrangement for people as against law. And also in the story, so in kind of the rise, there are real lessons to be gleaned. And in the fall, there are lessons to be gleaned as well. Like, why did the bar shut down the auto clubs? Whose interests were they serving? And who's been assisted by that reordering? And how do kind of the remnants of that reordering continue to shape the delivery of legal services, and in my view, continue to skew and stunt the delivery of legal services?
Thank you. Yeah, like I said, the article is fascinating. I encourage everyone to read it, and it's really interesting because it uncovers something that I think not a lot of people knew existed at one point, and we're thinking about how does that impact how we think about things today when you sort of assume things have always been this way and it hasn't. And so I'm really excited to dig more into that. But let's turn, Brad, to you and your chapter, The Case for Traditionalists, where you argue that UPL restrictions serve to protect the public side of lawyers' duties in the delivery of legal services. So it's not, it is a complicated story. It's not necessarily like all evil, right? There's something there we do need to regulate. We do need to be deliberate and think about how we're allowing people to serve the public. So can you walk us through a little bit about your frame? And I want to encourage this to be a conversation, so feel free to respond and reply to anything Nora said as well.
Yeah, sure. And thanks, Malka, and thanks to all of you for having me, and to Nora for originally including me in this project. And I just want to second what others have said. The Auto Club's paper is awesome, and it's not only intellectually rich, but it's a good read. It's a page turner. Not often do I say that about law review articles. So please, everyone, read it. So I think I'm the designated dinosaur, and you need something like that. You need a foil to write against in these areas, and so I'm putting in a brief for UPL restrictions. And the major theme is that it's easy to see them as anti-competitive and harmful to consumers, and they are that, right? And I'm not opposed to sensible UPL reform, but I wanted to try to make the best case for UPL restrictions, and then let others argue against the best case, and not some imagined case. And so the best case has to do with what it is that we expect lawyers to do. And I don't mean, the legal profession writ large in this institutional way, but individual lawyers, like what do they provide? And one of the things they provide, and I talk about this a lot in the chapter, is professional judgment. Now, this is a concept that got cited endlessly in the 1990s when former Yale Law School Dean Tony Kronman published a book called The Lost Lawyer, where he talked about professional judgment being this essential thing that lawyers possess. And for him, it's this paired virtue of sympathy and detachment, both of those things. If that sounds too abstract, take the common lawyer slogan, zealous advocacy within the bounds of the law. You've heard that a zillion times. Lawyers love to say that. Now, they sometimes forget the within the bounds of the law part, and they just talk about zealous advocacy. And there's a bit of a problem in colonizing other areas of practice with an advocacy norm, transactional and compliance counseling. But the idea of zealous advocacy within the bounds of the law catches this paired virtue that Kronman was all about with sympathy and detachment. So the way I think of lawyers' duties, it's not just client facing. And a lot of critiques of UPL is like, look, we can assure quality in other ways. We can use market mechanisms or other kinds of regulatory mechanisms to ensure that consumers get quality legal services. Cool, I got that. But that's not all lawyers owe. They have client-facing duties and they have public-facing duties. And by public-facing duties, I mean this within the bounds of the law bit, right? Sympathy and detachment. Lawyers have to be able to approach their clients' positions, whether in litigation or in a transactional practice or in a counseling and advising compliance kind of role, with sympathy and detachment, and be able to say, wait a second, you can't do that. Now, you often hear this cashed out in terms of lawyers should practice their craft in the public interest. I agree in a sense. I agree that lawyers have a duty to the public interest, but that's the public interest as it is embodied in the political community's laws. It's not some free-floating concept that lawyers can tap into and say, client, you're acting in some way that's contrary to the public interest. Rather, it is bringing the client's preferred course of action into alignment with what the law permits or requires. Now, I don't think the law is self-applying. I don't believe in mechanical jurisprudence. I'm a post-realist like most academics. And I think there's something very important to the idea of professional craft in interpretation. And if you don't believe me, go back to your first year law classes and think, what are we doing in torts and contracts and all of those classes? We're teaching students to differentiate between something that may be superficially plausible versus something that lines up in the right way with what the law is trying to do and its underlying policies and sense and coherence. That's what you're doing in law school, is you're teaching this craft of interpretation. And I also think that along with that, there's an ethical component, which is respecting the framework of the rule of law and legality while providing legal services. So I have some examples in the book, and we can talk about them later in the Q&A, but they're meant to be relatively, I don't want to say routine, but sort of ordinary legal services where there's nevertheless a component of judgment. And my take on UPL restrictions is, if we open this up, the market for legal services, to other kinds of legal human service providers or AI enabled or teched up legal services providers, I just want to know how we ensure that those providers of services will exercise judgment in the same way that we expect lawyers to. Where I think lawyers acquire the capacity for exercising judgment through training and socialization and experience, I just want to know how we can do that with other service providers.
Thank you for that. Yes. And we really appreciate your perspective. I think in some ways, a lot of these perspectives can seem to butt up against each other, but are actually very complementary. It's everyone kind of coming from a different angle of like, how do we do this in the right and thoughtful way? And so, Bridget, we're so excited to have you here, especially because I think it's really important to have people who are on the ground, not just academics, in these conversations to really talk about the practical implications. And so I know you've seen the legal system from at least two angles, right? With your prior role as Chief Justice of the Michigan Supreme Court and your current role leading the American Arbitration Association. And so I'm really curious about how these roles have shaped your perspective in thinking about these questions in legal service delivery. And do you think of them sort of in two separate frameworks from these two different experiences, or do you see kind of an overarching theme based on both of these roles?
Thanks, Malka, and thanks to the Rhode Center for organizing this great series and including me in it, and letting me be the person on the ground. I love being the person on the ground. That's fun. I did spend 15 years on the law faculty, so I can speak that language as well if you need me to. But I'm not. But it's not my native language anymore. And I also was a practicing lawyer when I started my career. So I feel like I've developed a perspective across 4 chapters, but the last 2 have been pretty significant. And my view is they give me a unified perspective, even though from different vantage points. And let me explain. Let me say a little bit more. As as the Chief Justice, like every other state Supreme Court, we were constitutionally responsible for administering the courts of the state. And what that meant in Michigan in practice was 242 trial courts with 180 different funding units with different amounts of money and priorities, and nearly 1,000 separately elected judicial officers administering between 3 and 4 million cases a year. And the overwhelming reality was that on most of the civil docket, people were showing up without lawyers, or not showing up at all. And they missed court dates because they couldn't find childcare, they couldn't take time off work, they couldn't get transportation to the courthouse. And these are not people who chose to go without legal help. They simply had no realistic path to getting it. By the way, Nora, I loved the piece, and people often think that when I say I work for the AAA now, that I work for the maps, that I make the maps. They're like, "Really? You're the CEO of the AAA? You make the maps?" And I'm like, well, no, the other AAA, and there's no AAA, so folks, simply have no AAA to help with legal services, no realistic path to get help, and that's quite frustrating and sometimes worse for the judges who every judge I've met decided to do the job because they wanted to serve their community, right? They wanted to serve the public and they wanted to do it well. But that's what they're seeing every day, and it tells you that the current system is which was built a long time ago around the assumption that a licensed attorney would be standing next to every person who walked through the door, is no longer working for most Americans. And there are real impacts of that that are being felt across communities and in courthouses. At the AAA, I see a different vantage point, but it's a complementary one in my view. The American Arbitration Association provides all kinds of alternative dispute resolution services, not just arbitration. That's just the name from 100 years ago. We turned 100 a couple of weeks ago. And the founding premise at the AAA, which I assumed in 1926 was a response to crowded dockets because of the Industrial Revolution, and that's not the case. The founding premise was that a really incredible woman named Frances Keller, who was active in every important social issue at the time, and got interested in giving people at the individual level, not just businesses and organizations and governments, agency over resolving disputes. It was her theory that would result in better outcomes for the folks who chose that, and that was going to serve as a support system for the public dispute resolution system. So it really was an additive view. Ask me more about Frances Keller at another time when we can talk about her, because she's amazing. But that view persists. Like the idea that when people choose it, they can design their own dispute resolution process and therefore have real agency over how they resolve conflict. That does grow confidence in outcomes. And there's a somewhat robust procedural academic literature on procedural fairness, procedural justice that echoes that idea. And it's the same in courts. They're just working with 1.5 arms behind their back to try and figure out how to give the public more options to grow trust in the process. So I think that the framework, the overarching framework I bring, is that the question isn't whether we're protecting the monopoly of lawyers or dismantling it. It's not really zero sum. It's a question of whether the systems we've built and maintained in courts, in private dispute resolution that supports courts, in legal services more broadly, are actually serving the people they're supposed to serve. And if not, then those of us in positions of institutional leadership have some obligation to figure out how to make them better. And we did a lot of that during the pandemic. We proved that we could actually innovate. We learned that even though we had it beaten out of us in law school, that we actually still could figure out how to innovate, some of us, and that was fun. And we learned a lot from it. We dramatically increased access just by giving people remote, a way to appear at court hearings remotely. It wasn't a complicated lesson. I mean, courts and legal institutions learned a whole lot fairly easily. Sadly, there's been a lot of walking back of that. And so I think the harder questions are whether we want to make some of those innovations permanent and continue to experiment. In ADR, in mediation and arbitration, we have a significant, at least at the AAA, maybe not in other institutions, but the AAA, we have a significant number of self-represented parties. And we have spent a lot of time over the last 2 years improving the materials we provide to them to help them navigate the process. It's a lot easier than in a court. We get to if we do well, we're a fee-for-service nonprofit. We do well, we invest money in R&D. We figure out we can innovate quickly. We have a funded innovation team at the AAA. That's not something I had at a courthouse. I was having to convince some legislature from Roscommon to vote yes on that ODR funding, and that took me forever. So it's easier and faster in this context in a way than we can learn faster what works for people navigating their own legal problems without the help of a lawyer. So I think the question is whether the way we currently define and regulate the provision of legal services is calibrated to the needs of the public, or whether it's calibrated to the interests of the profession. And that's where I spend a lot of my brain space.
Yeah, and can I just jump in here, which is to say, I think we've all been kind of assuming some knowledge on the part of folks who are listening or watching, and I'm guessing that in some places that's really justified, that we have real experts who are taking part today. But for those who aren't experts, I just want to kind of set the table a little bit more, because I think what we've all said, I've kind of assumed. I was talking about the access to justice crisis, and Bridget was talking about the judges go to the role with one set of commitments and goals, and yet often find their work really the reverse of what they intended. So just a couple facts to set the table, which is when we talk about the access to justice crisis, I think what we're all talking about is that in roughly 3/4 of cases in American courts, at least one side lacks a lawyer. In some cases, both sides do, but at least one side lacks a lawyer in roughly 3/4 of cases. In some kinds of cases, disparities are even sharper. So in some jurisdictions, 98% of people facing evictions lack lawyers. In some jurisdictions, 99% of those in consumer credit matters lack lawyers. In some jurisdictions, 95% of parents in child support cases lack lawyers. Even in federal courts, which we tend to think of as better resourced and kind of the Cadillac of our courts, representation is scarce. So the majority of appeals in federal court are pursued by unrepresented individuals. Very often it's not that people make it into court without lawyers, it's that folks don't make it into court at all. Even on the defendant side, certain kinds of cases, default judgment rates, a default judgment is obtained when you never make it into court, and so the court just issues a default judgment against you, can approach 90%. That's in consumer credit matters, debt collection matters. It's around 60% in eviction matters. And then we have, I always call it a layer cake of a calamity, because those are all the kind of the folks who are defendants. And then we're not seeing the folks, the individuals who are plaintiffs, because it is so freaking hard to vindicate your rights in the current system. So the current system is really stacked against the vindication of rights. So there are lots of folks with lots of rights. Think of a worker entitled to overtime, a voter who is entitled to cast a vote but isn't able to, an insured who has a claim but the insurance company is not paying it, and so they just eat the cost, a person who needs a domestic violence restraining order but is unable to obtain one. The courts are not doing well at all when it comes to being open for the vindication of rights. So I think of courts very much right now as the Robin Hood in reverse, which is right now our civil courts essentially take from the poor to give to the rich. So we see that in debt collection actions. We take from the poor to give a debt collection action judgment and a wage garnishment to the rich. We see that in landlord-tenant cases. We evict the poor to give the apartment back to the rich. We see that in home foreclosure matters. But when it comes to the poor folks who want to vindicate their rights, who have an entitlement under the formal law, the courts are very often unavailable. So this is when we think about the access to justice crisis and how do we address it. I think that's kind of a scene setting of kind of what we're talking about here.
Thank you so much, Nora. And I think it is so easy to kind of use these buzzwords, and they're used a lot. And it's really helpful when you get the statistics and you hear these like astounding numbers. I think it really brings it home, and it's like that's what we're here to talk about. And so I think that's really useful. Like even people who are well in this space, I think it's always useful to take a step back and remember that these are the literal numbers we're dealing with right now. It sounds like, we've laid out some groundwork, we've talked about some frameworks, and now I want to dig in a little bit more. And so I'm actually going to stay with you, Bridget, on this, especially because I think it ties into two of the things that you brought up. So I think first, I'm really interested. I think a lot of times when they talk about the access to justice crisis that Nora was describing, we think a lot about lawyers' roles and what to do about that. I'm really interested in sort of how you viewed the role of a judge when it comes to access to justice. How much can you impact, and how much, where are the places where a judge can weigh in and get involved? And so I think there's that piece I'm really interested in. The other one that you raised, and this is for the whole group to think about too, is when we're talking about AI and technology, there's obviously so many potential upsides for access to justice. But then there is the question of how do we make sure, and this gets to Brad's kind of thesis that he laid out, which is like, how do we make sure that they're exercising, sufficient judgment and they're making the calls that we feel comfortable with when there's less human involvement? And so I know those are two different questions, but I think you've raised both of them, and I think they're worth the whole group talking and thinking about.
Yeah, so let me start with the question about the role of judges in improving the system they oversee. And my overarching response is, if not judges, then who? If it isn't their lane to improve the system they oversee, whose lane is it? Or is someone else going to come do it? Because if they are, great. Tell me who they are, and let me talk to them briefly. I have some ideas for them, but I don't know of anybody else who's like coming to do it. We judges take an oath to uphold the law. Okay, that's really important. In any individual case, you can't be like improving the system. You're deciding legal questions, and you're deciding them without fear or favor. They also take an oath to serve the public, and the service to the public is falling short in most courthouses across the country, as Nora explained. And if you are the administrative head of a particular court system, which many judges are, there's like a chief judge in every courthouse usually, or at least in every county. You have a part of your role that's more than adjudicating cases. You have to look at how your system is working and ask, who is it working well for and who is it failing? Right now, in many places, there are obviously exceptions. There are judges doing incredibly innovative things in small pockets across the country, but overwhelmingly, the court system is designed to be inhospitable to people without lawyers. Forms are not comprehensible. Procedures assume representation. It's even hard to figure out where the procedures are. They're often in 7 different places. There's like a statute that says some stuff, and then there are court rules that say some stuff, and then some judges have their own rules that might be on a website, but they might not because they don't like websites always. So it's a very hard process for people without lawyers to navigate. Courthouses are only open during business hours. If you design a system for lawyers and then 80% or 92% of the people using it don't have one, that's a design flaw. That's simply the way that is now. So what does that mean for moving beyond lawyer-centric solutions and the role judges have in it? I think it means that judges have to be willing to think about who else can help them figure this out. And what tools can make the system more navigable. And so I'll answer your AI question as well briefly in a minute, or do my best with it, I should say. And what regulatory system would enable those kinds of solutions, because you need all parts of that. There's only so much you can do without the infrastructure behind it. And I think there are lots of judges and courts who are eager to figure that out. Not all, of course. There have been some backtracking on COVID innovations, which I think are unfortunate, but I do think for the most part there are judges looking to figure out how to do better. One of the, one very small example that's not tech heavy that we used in Michigan was we ran expungement clinics that we took on the road. We took a van with lawyers and sheriffs and volunteer law students. You didn't really need lawyers. I mean, we were willing to have lawyers if they were free and available. We're not against. I love lawyers. Some of my best friends are lawyers. But if they're not available, there were lots of others who could actually figure out the expungement process, which, by the way, is one of the most complicated ones, at least in Michigan, to navigate even for lawyers. So if we got a group of specialists together who could do it, and we could show up and tell community such and such that we're going to be there on this day for 2 days, and we're going to help you get your expungement done. That grows trust in our court system, in our judicial system, so much faster than anything else a court could do. And it was very low tech. I mean, there was a printer in the van, I think, and a laptop, but it was pretty low tech. I think that the inability of courts and judges to embrace changes that give people more options to access justice is at least as significant a threat to the judicial system as partisanship and polarization, which is what most people are focused on and thinking about. The judiciary has neither the power of the purse or the power of the sword, blah, blah, blah. We all know that. It has only the people's trust and confidence. And if most Americans can't meaningfully participate in their own legal proceedings, we're going to lose their trust. There's no doubt about it, or maybe we've already lost it in some places. And if judges don't have the ability to be part of finding those solutions, I think we're in trouble, because they're the ones that have the best information and the best evidence about what's working and what's not. Technology will absolutely be part of the solution, but from my expungement van example, it's not the whole solution. AI obviously is the latest and perhaps the most democratized part of that solution, and that's exciting in lots of ways. I don't know if we're going to get into the new lawsuit against OpenAI, but if we are, let's do it. But the new UPL lawsuit, I should say. But I agree with Bradley that we do want to make sure that our generative AI systems are infused with the right values, to the extent they are acting to guide people through legal issues. And that is a little bit under theorized, I think, by lots of folks right now. And I do spend a little bit of time worrying about that more in the dispute resolution space than the advocacy space, just to put my cards on the table. That's where I'm thinking about this technology having a tremendous impact. I'm much more of an optimist than not, but I do believe that it matters what values that the system has learned.
So can I just give an example to illustrate that? Because I think it's fairly abstract to talk about values and what that means. But I have 3 examples in the chapter, and a couple of them are much discussed. One of them, which I'm going to talk about now, is from a Cornell Law School immigration and asylum clinic, and I function as in-house counsel to the clinics. And so I actually worked on this as an ethics advisor. And so you can think about this in a technologically enabled way or a non-tech way. You can think about some sort of legal services provider being a human or a robot for the following case. So the case goes like this. There's an asylum applicant from Sierra Leone, and he claims credible threat of persecution in his home country on the basis of his sexual orientation. He says he was single, no kids, attended a support group for gay people, which was repeatedly attacked by a violent anti-gay group. He goes through the immigration judge process. The immigration judge enters an adverse credibility finding, so it goes up on appeal to the BIA. So the proceeding is still pending. He says to the students in the clinic while this is going on, "Hey, so if I get asylum, can I bring my wife and kids?" And they go, "Excuse me, what? Wife and kids? Yeah, you talked about your sexual orientation. You said at the hearing you didn't have any wife and kids." And he said, "Well, My friend filled out the application. He was mistaken. I'm not gay, but I did go to this group because I was supportive, and I think I could be subject to persecution on that basis in my home country. All right. So now what do we do? So a lot of things are happening here, and the question for the reformers, and I consider myself a reformer too. We talk about consumer debt, and I think like the Upsolve organization in New York should be able to counsel people on how to fill out standardized forms in consumer debt cases. So I'm not completely a dinosaur. But I just want to make sure that we understand what the steps of judgment are that are involved here. The first thing is spotting the issue. Wait a second. Has a lawyer introduced false evidence? Now, are there obligations to take remedial measures? Under the rules that apply to lawyers, query whether that's going to apply also to non-lawyer service providers, the obligations to take remedial measures apply if the lawyer knows the evidence is false. Does the lawyer know? You got two different versions. You have the client's version, and you have the um, uh, what a reasonable person might think was going on. Does the lawyer know it's false? What then remedial measures have to be taken? The clinic professor and I and the students worked through this for a long time, and we're very careful in trying to figure this out. And I just wonder whether someone without the training and socialization in law would spot that issue, think about how to resolve it, and then be able to work through a resolution. That's what I mean by infusing the right values. I mean, I'm an ethicist, and so I'm all in favor of values, but I'm also a lawyer. And so I want to situate those in concrete cases. I want to ask, what do you do? In this kind of case, how would you guarantee that the services provided are not just, a funnel for channeling lies into the system, or they're, precluding people from asserting evidence that may be kind of dubious but isn't knowingly false? I mean, these are just a tricky balance, right? And the rule embodies a tricky balance, and professional judgment and socialization and training is all about learning to work with that. That's just what I'm saying. I want to make sure gets captured in whatever, post UPL reform project we set ourselves to.
Can I jump in? I mean, absolutely, I agree that we want, whatever kind of legal system 2.0 to be as ethical and responsible as possible. But I do think when we say, we need a guarantee that the non-lawyers would spot this, like I mean, I'm very glad that in an Ivy League clinic with you as their advisor, they were able to spot and work through that issue. But I have no confidence that that happens, broadly across the system of lawyers, and nor do I know that there's a disjunction with non-lawyers. And part of that is that we have no data on how lawyers perform. We have no objective quality information on the performance of lawyers. We have that information when it comes to doctors. We have really good objective information about how doctors perform, and we can look and, when I was pregnant, I remember looking very carefully. I didn't want to have a C-section, so I was able to look at different hospital C-section rates, and I was able to compare them, and I was able to make an informed judgment. When it came to sending my kids to school, I was able to look at the schools and what their test scores were, and recognizing that they're imperfect and can be gamed, and 87 different caveats. I was able to look at some data and some information. No one today who wants to go to a lawyer has any of that information available. It's not available, about lawyers. It is not available about non-lawyers. And so before we start worrying about non-lawyers will be deficient, I just want to have some sort of toehold. If we're going to make big and consequential decisions, I want it to be based on data, not on anecdote. And all we have now when it comes to this kind of thing is anecdote. Now, separately, actually, it was this impulse that Natalie Knowlton, who is at the Rhode Center and an extremely gifted researcher and scholar, she and I wrote a paper this summer where it was me saying, like, I want to get every scrap of evidence over the past 150 years comparing lawyers to non-lawyers in the United States. I want every letter. I want every study. And then, oh, by the way, let's look at outside the United States too, because there's some information there. And we wrote a piece doing that work And what we found in that piece of looking at dozens of studies conducted at different time using different methodologies and different metrics, is that there is very, very, very little difference. In some places, lawyers surpass non-lawyers. In some places, non-lawyers surpass lawyers, based on different, based on different metrics and different kinds of assessments. Some of these are objective and some of these are subjective. Um, and so before we have some sort of assumption of, well, non-lawyers don't have this like thoughtful professional judgment and lawyers do, I need to see more. I need to see the receipts on that.
I'm hopping in as well. I talk about this often, but in the context of judges. And my question is always, as opposed to what? Tell me what data I have that you have that judges don't make mistakes right now. Because as far as I can tell, the whole entire appellate court system is built around the fact that we expect judges to make mistakes. They do make mistakes, lots of them. We only fix some of them. They have to be material for us to fix them. Many mistakes just go unfixed. We never have, visibility into judges' brains to understand how they make a decision, right? That's something we just assume on behalf of humans is done well. And with respect to technology, at least, which is where I'm asked to talk a lot about the comparison, we want perfection. We want auditability, which I actually think we should have. That's part of growing trust. But as opposed to what and how comfortable we are with the lack of information with respect to the status quo should give us a bit of pause, I think.
And one more thing, which is I want to, when we're thinking about risk trade-offs here, which is what we're thinking about, risks of non-lawyers versus risks of lawyers. Something else we should be thinking about is going back to Bridget's point from a few moments ago, which is the risk of the status quo. And the risk of the status quo, I think, is that people will give up on courts. So I've got kind of one of the things on my desk is kind of above my desk is 28% of low-income Americans think that the civil justice system treats them fairly. That to me is a like 5-alarm fire. And for the reasons that Bridget said, which is, we don't have the purse, we don't have the force, we have the sense of legitimacy. And what happens when we squander that? So political scientists, 20 years ago talked about democracy at the DMV. And there was a sense that people's touch point with their government was at the DMV. And so when it was disorganized and when people are rude and when they can't get you your driver, going back to driving, you can't get your driver's license on time and you've messed up the car registration, people lose their faith in government. Now I think people's touch point with their government is very, very often the civil justice system. It's where your wages are garnished. It's where you're evicted. It's where your house is foreclosed upon. It's where they, when you need protection from your abusive spouse, that they give you the runaround and can't give you the form you need, and they're closed on the one day you have off of work. And the lines are long and the service is sometimes inattentive. And that, I think, is a real problem. And so when I think about risk versus trade-offs, I want to make sure that those trade-offs and the risk that comes from 28% of low-income Americans believe that the civil justice system treats them fairly, that we make sure that we solidly put that on to any kind of comparative equation, because that is a piece of data, and I find it alarming.
So just very quick, I won't take much time on this, but Nora and I are both torts teachers too, and so risk trade-offs are close to my heart. But here's an example of something where I think we see the pressure going the other direction. I'm sort of like a 1960s liberal in the sense that I recognize a public-private distinction. I still think it matters. What is one thing I think we can all agree the legal profession is completely freaked out about, almost uniformly? Private equity. Oh my God, non-lawyer investments in law firms. We're going to have some kind of loss of independence and control if the legal profession allows the private sector to get involved too much. I don't know what proposals we're talking about here in terms of AI or whatever, but a lot of these things are provided by private actors, and we're really worried about the impact of that on professional values. Don't take my word for it. Look at the debates around non-lawyer investments in law firms and private equity and things like that. The profession is completely flipped out about that. And now, if you think they shouldn't, they think they should calm down, that's great. But if you see there's something there, then you see what we've identified as the risk here in moving from the legal profession and courts to some other system of, allocating rights and responsibilities and adjudicating and things like that.
Thank you. Yes, this has been so rich, and honestly, your answers and discussions I've just found so illuminating. So I do want to move to audience questions, and then if we have some time, maybe everyone can do some closing remarks. But I think that you know, being in discussion with each other is so much better than just straight questions and answers. So I think it's been really fun to hear each of you react to each other. So we're going to start with the first question from our audience. And the question is, can law still be conceived of as a public profession? And if so, why shouldn't the limits of the monopoly and privileges be determined by or on behalf of the public? In other words, through an independent regulator rather than by the profession itself. So I'll open it to all three of you. Does anyone have an instant reaction?
I'll jump in here, which is, so that was one of the things we found in this Auto Clubs piece, which is, I had for years taught my students about, law self-regulating and I had never really thought like why and how, like when did that come to be? Um, and the answer is it was in these battles. It was when the bar was shutting down auto clubs, which, by the way, and auto clubs, to make sure it's clear, they were providing services from lawyers. So it wasn't like the old style UPL. It was lawyers, and it was this non-lawyer ownership. It was exactly the debates today. Like it was the auto club employing the lawyer, not venture capital, but it was what's called corporate legal services was the big no-no that the bar recognized. And then the bar, in shutting down the auto clubs, really for the first time minted this argument about we are the only ones who can regulate law practice. It's you courts. And they were doing it, they were advancing this argument because the legislatures kept on creating carve-outs to allow auto clubs to continue to operate. And so the only way to get the legislator basically to quiet down and to shut down, like the legislature wasn't going to shut down the auto clubs. The auto clubs were too popular. So the bar had to go to the courts and say to the courts, it's only you, tell the legislature they can't, and make it the self-regulating profession. And some states took it to what I view as kind of absurdist lengths. And, In re Supreme Court was decided by the Massachusetts Supreme Court. And what the Massachusetts Supreme Court said is as long as the legislature is limiting the supply of legal services, they are acting within their domain. They are constitutionally competent to limit the supply of legal services. If they are expanding the supply of legal services, that's unconstitutional. So any kind of expansion on the supply of legal services can only be done by the court, but as long as it's shutting it down, no problem here. So I do think that there are the UPL ban has rotten roots, and this like self-regulation thing has rotten roots. And I think in any kind of assessment of whether it makes sense, we got to understand, like, I'm a big believer, you don't know where you are unless you know where you come from. And where this comes from is it smells.
Thank you for that. Yeah. I want the next question actually is specifically to you, Brad. And I want to say my own view, which is like I think it's very easy to say the system is broken. Let's get more people in the room. Let's get more players involved. But I also have a lot of sympathy and understanding for this idea that it does have to be done correctly. And that I think is a really tricky question, especially when you look at the roots being a little fishy. The question is, how do we explain UPL restrictions to the millions of people who cannot afford lawyers and cannot access free ones?
Yeah, no, I appreciate that. And again, let me go back to something I said before and say I'm not an opponent of sensible UPL reform. So I was initially licensed in Washington State. And so I kind of followed the triple LT, limited license legal technician thing that Washington State was doing with some interest. I thought, good for my state. But they made it so onerous. They made the training pathway so expensive and they made the supervision requirements so unrealistic that it just died. Now, I am not by any means a social scientist or a comparative professions scholar, but it seems to me that the healthcare professions are doing better with this, with nurse practitioners and PAs and allied professionals like chiropractors and acupuncturists. And I live in Ithaca, New York, the home of all of this stuff. You can get any kind of healthcare here. And it all seems to contribute to well-being in some way and health. Now, it's got to be regulated. You got to be careful with it. But it seems like medicine's a little bit farther on down the road. Let me be clear. I am all for this, right? I'm not opposed to some kind of UPL reform and cases like the Upsolve case in New York, where you have trained community justice advocates who understand how to help consumer debtors fill out these form answers to avoid being defaulted in debt collection actions. Awesome. I mean, I think it was a weird pathway to get to the litigation using the First Amendment as a lever against UPL restrictions. But that aside, I think that sort of thing, and Nora's point about the negative inherent powers doctrine about whether the judiciary has the exclusive power to regulate the legal profession can also be problematic. But if we can work out all of those institutional and constitutional complexities, I'm all in favor of opening the door. And so when people are denied access to legal services, I would say we're working on it. We're trying. We want to get you better legal services. I'm not defending the traditional monopoly in all its in all its rotten roots form. I think there are problems with it. So I'm not an opponent of reform. I just want to make sure that we don't lose some important stuff along the way.
Absolutely. Yeah. And I agree with that. And I did immigration work before I came here, and I think I saw the harms that can occur when you have people who should not be involved in that process doing some really bad work, and especially people who are not lawyers trying to get involved. And so I do agree that like there still has to be, regulation. The question is like, how do we do it? And kind of on that note, I'm really interested in like, and this is a question that we've just gotten in from the audience, and it's to everyone. And Bridget, I'm really curious about, if you have any as well, but I think people want us to end on a somewhat uplifting note. So they want to think about, are there examples or developments, both outside the United States, or like Bridget, you were saying, there are some judges or courts that are doing things within the United States that are maybe unique, or they're experimenting, that, give us some case studies or some hope that we might be able to, improve this system in a way that is meaningful but thoughtful.
Yeah, there are lots of examples across the United States of individual judges in their individual courtrooms or sometimes outside of their courtrooms. Some of the most innovative solutions I've seen are outside of their courtrooms, are really improving the service to the public. And the problem, of course, is how to scale that if there are regulatory barriers to scaling some of those solutions. And that's, I think, why we're having this series, and we're kicking it off today with this conversation. So I think the scaling is the problem in the US. I bet Nora and Bradley have better information about other jurisdictions, although I know in England and Wales and Canada, we have lots of examples of successful people other than lawyers figuring out how to help navigate legal problems. I also think alternative dispute resolution is going to be a bigger and bigger part of the answer. I mean, again, it's my view that ADR systems should complement public dispute resolution systems, and especially when nonprofits run them, you can build those and experiment sometimes in those in ways that are faster, and you can learn more quickly about what might work. I was just looking at our statistics quickly today, of filing statistics, and our self-rep caseload is double right now what it was last year. So many I think most small and medium businesses in the U.S. also go legally naked. They can't afford lawyers and don't have lawyers, and I think they're finding ADR to be more navigable and a solution. And in ADR, you can sort of invent the process. You can say we're starting with mediation, and a lot of times that's just going to work. And we know a lot about how those results stick and grow confidence in dispute resolution processes, and you can move from there to some more adjudicative process if you want. So lots of room for innovation in ADR systems. And when you partner with courts, which we're also doing with the LA court system and Stanford, to build some of those new solutions, where people can navigate those solutions maybe online, outside of court hours, with access to better information. We might be able to, build entirely new ways of doing things. 100 years ago, arbitration was an innovation. It was an innovation. Like, that wasn't happening. It's 100 years later, but I think, we now have all this new technology that is allowing entirely new ways of resolving disputes. And so I'm optimistic about the combination of all of that, producing some good data for us to study and show the world.
Thank you. And yeah, Nora and Brad, I'm so curious, when you think about sort of what's coming next and you look at whether there are examples that exist out there right now of, like, I guess, Brad, are there examples of, ways to train that's not as onerous or, as difficult as the ones that we sometimes see with lawyers, but will still allow for some innovation in this way?
Boy, I'm not an optimist. And you just kind of temperamentally, and not in this area. The organized bar is just dug in and working hard. And if the legal profession is pretty small c conservative and resistant to disruption. And I know there's a lot of talk about AI is going to disrupt everything, and I'll believe it when I see it. The lawsuit against OpenAI is one part of this. Also just quality control, just getting AI systems tuned up to be effective is going to be a big problem for some of these vendors. Consumer facing AI. I just don't know. I feel like I'm glad the Rhode Center is doing the good work that it is, but I think it's a slog. I think it's a fight. I think the profession is dug in, and it has been fighting this for a long time. The Auto Club's paper is a good example of that, and good on y'all. I mean, I'm a theorist and a lawyer. I'm not an activist or an organizer or anything like that. So good on y'all for thinking about ways to do this, but I think it's a very, very difficult problem dealing with a really entrenched opposition.
Yeah, and Nora, I really want to hear your response to that. And I think that, like, one of the questions I wanted to ask, and I'm glad we have a couple minutes for, so I'll tie them together, is just right. Like, so we write papers, we try to collect this data, we try to show historical roots. So we're like unearthing some really problematic assumptions. And yet, obviously, there is still a long-standing belief that, we need these restrictions in order to protect the public, whether or not that's true. And so I just wonder, in your view, like, what will it take to convince people to accept innovation and development and change? And do you share some of Brad's pessimism that, like, we're just up against this really monstrous beast, and maybe the best we can do is almost be journalists and just say, this is what's happening? Or are we able to say, and here's how we convince you to come along with us?
Yeah, so my comparative advantage is, I'm not a politician, I'm not a lobbyist, I am a scholar. And so my comparative advantage is creating the factual template, and to, interrogating ideas, showing the roots of things. So it's others' job, hopefully some folks who are, on the call today, to take the facts, the information, and to move it in various directions. But that is happening. So, we have a map that we all keep up to date at the Rhode Center, places where reforms have been tried, places where reforms, are being debated, places where reforms are in place. We have to update that map all the time because states are showing innovation. And something that gives me real reason for optimism is this is not a blue state issue. This is not a red state issue. We're seeing innovative, thoughtful court leadership We're seeing that, in, one of the earliest, most important states here was Michigan under Bridget's leadership, but we're seeing that in Arizona. We're seeing it in Utah. We're seeing it in Texas. We're seeing it in the District of Columbia. We're seeing it in North Carolina. We're seeing it in my home state of South Carolina. California, which had been really resistant, is maybe showing some openness. So it's not going to be one size fits all. It's not going to be all at once. But I do think, I tell my kids, in this family, we clean up our own messes, right? Clean up your own mess. And I do believe deeply that this is the mess that lawyers have created. It is our obligation to clean it up. And I do see that there is activity. It is not, necessarily, from the organized, bar, that in kind of the ABA annual meetings, but I do see a spirit of innovation and experimentation from very, from brave judges and lawyers and academics across the country, and that gives me some reason for optimism.
Thank you. So we're at 11 o'clock. So I just wanted to first just say thank you to our panel. I have found this to be incredibly interesting. I have been informed that we had lots of questions that we were not able to get to. We will do our best to review them and respond if we can. So everyone who's out there, just know we will try and take a look. And I just want to also flag that our next session, which will be called Lessons from the Field, On-the-Ground Efforts to Affect Positive Regulatory Innovations, will be on April 13th at 10 a.m. And we hope that so many of you can join us. So I just want to say thank you again to this group. And I just want to say that, even though there is some negative, it's not all a happy story. I think these conversations and these discussions have real value to continue to ask everyone to be thinking about it, including everyone in the conversation. So thank you all so much. And I hope you have a great rest of your day.
Thank you.
Thank you.